Yo, what up, guys? It's Derp with another video about the IronMace vs. Nexon court case. This time I've got some information about the motion for dismissal that IronMace applied for a few days ago. So let's kind of get right into it. So there's been a few videos, Reddit posts, and a lot of other discussion on the Discord. There's been YouTube videos, all kinds of stuff about this already. And this video is kind of to address some of the misinformation, speculation, and other issues popping up surrounding this topic. And because of that, this video is going to be a tiny bit longer. So I wanted to get through it as quickly as possible. And here's kind of what I'm going to cover. It's going to be what is a motion to dismiss. I'm going to cover the major Reddit post that I saw and some two comments that have been gaining a lot of traction. There's a popular video, I think we've all seen it, that discusses the topic, and I wanted to address some things in that. I want to address the likelihood of success of the dismissal, what this means for the United States case, what this means for the Korean case. Then I'm going to get into something called the WIPO, World Intellectual Property Organization, as well as the World Trade Organization. I'm going to get into what this means for the DMCAs, and what this means for early access, and a TLDR at the end, right? So before I get into the video, I want to say thank you to everybody who's been watching my videos and subscribing to the channel. You guys are all amazing. I went from like 300 subscribers to now I'm almost at 700, and it's making me really want to keep pushing, doing content, and I want to try to get to that 1,000 sub mark. And you guys are helping me do that. You guys are amazing, and you guys have been an amazing community, and I want to kind of give back any way I can, and the way I know how is content and research and answering questions. So your comments, your suggestions, your questions, and insight into the case has been a beacon of hope in this dark times without the game we all want to play, which is dark and darker. I can't thank you guys all enough. My new goal is to break 1,000 subs by the end of next month. I'm closing in on that goal each day, and I'm already over 650 subs, closing in on 700 as of the last time I checked. So please like, subscribe, leave a comment. Everything you do helps me out a lot. If you guys want to reach out to me, please consider joining my Discord or my Patreon. I'll have links to those in the description below. Again, honestly, thank you guys all so much. You're amazing. You guys are awesome. But yeah, let's do what we came here for and get into this video. Starting with the motion, what the motion to dismiss is all about. So what is a motion to dismiss? First we need to understand what a motion to dismiss is. It's pretty clear in the name. It's something that happens when a person involved in a court case, either the plaintiff or the defendant, asks the court/judge to dismiss the case, right? Quick excerpt from Cornell Law. A motion to dismiss is a formal request for a court to dismiss a case. Pretty simple, right? So we also need to understand how common this is and be realistic about the outcome. Motions to dismiss are exceedingly common, with Cornell Law estimating that 97% of all federal lawsuits are dismissed in some way. Mostly this is done through settlements. To better understand the specifics of dismissal, we need to understand this dismissal specifically, we need to understand what a motion to dismiss on grounds of forms of non-convenience is. According to Cornell Law, again, I trust this source. They're one of the leading experts in law in the country. Forum non-convenience refers to a court's discretionary power to decline to exercise its jurisdiction where another court or forum may conveniently hear the case. Dismissing a case on forum non-convenience is not a bar for judicata purposes, and therefore does not prevent a plaintiff from refiling their case in the more appropriate forum. So it basically doesn't mean that if this case gets dismissed, they can still try it again somewhere else, right? This doctrine may be invoked by either a defendant or sua sponte by the court. So the court could actually decide if this is applicable. Basically, what this means is that the courts are willing to dismiss a case when the case is already being handled by another court in a similar way, We have a good example of this in the Nexon versus IronMace case, where it is now being tried in both US and Korea, right? So this is a good example of that. IronMace's argument is that they shouldn't have to fight the same case in two different courts at the same time, especially since the cases and requests from both cases are so similar. They're asking the US courts to dismiss the case so that they can focus on the Korean court cases and not waste the time of the US courts, not waste their money. And there's actually a contractual issue to it as well. But their largest argument seems to be that, you know, they are Korean nationals. Nexon is based in Korea. IronMace is based in Korea. All the evidence, everything is based in Korea. Everything's in Korean. So they don't want to waste the court's time and money by having everything translated and shipped over to the United States and copied. And it's going to take hours of, like, a whole bunch of man hours to have approved translations and everything. And they just don't want to deal with the hassle. They don't want the court to deal with the hassle, so it's just better to do this in Korea, where it takes precedence anyway, right? Whatever happens in Korea is going to be more applicable to both companies because they're both based in Korea. So it just makes sense. IronMace is also pointing to their employment contracts with Nexon, saying that their contract has a clause that states that all cases against one another would take place in a convenient jurisdiction, meaning Korea. This is unconfirmed. This has been argued in court under, you know, it's now in testimony in court, basically. So if they're lying, they're in trouble. But I haven't seen this contract, and I don't think anybody else has. So, but yeah, that's what IronMace's lawyers are claiming, and they wouldn't make that claim lightly. So with that in mind, let's move on to what the wacky people of Reddit are claiming. So let's dig our claws into this juicy little Reddit post covering the topic. There's a lot of opinions on whether or not the dismissal will be approved or not. Some of these come from people claiming to be lawyers. I have a link to the Reddit post here. As a reminder, I myself am not a lawyer, nor do I claim to be. This is not legal advice. I'm just relaying information. However, I am good at research, and I have some friends that are lawyers that I've spoken with, and, you know, I grew up with them or have worked with them directly, so I know these people firsthand, right? I trust them. I've asked them what I could, I've asked them what I could, and they have looked into things, and they've pointed me in directions. They've given me research to look at. They're not really hand-holding me a lot. They're just kind of giving me their opinion and then telling me where I should look, right? Now, with that in mind, I want to break some things down. I want to confirm some stuff, and I want to refute some things and help validate some things that are going on in this post. Because this is what a lot of people are linking to in the Discord and, you know, on Reddit and even in videos that I've been seeing pop up. So first, let's get into the Thrice Bard's comment. He starts off by explaining what the motion is. This is a motion to dismiss forum non-convenience, which is a doctrine that more or less stands for the proposal the lawsuit should occur in a convenient court. Agreed. That's true. Distilling the legal principles at play, IronMace makes a handful of arguments about why the court should dismiss the lawsuit and allow the parties to litigate their dispute in the already pending action in Korean court. They say that Korea is perfectly adequate to a perfectly adequate forum and has sufficient legal protections for Nexon. They argue that the companies and witnesses at issue are all located in Korea, making litigation in Washington far less convenient. And they claim that Nexon's employment contract with its former employees obligates it to litigate the case in Korea, as this case relates to their former employment. Now, from what I understand, and from what I've been told, everything this guy is saying is correct. As seen in the motion itself, so they refer to this stuff a lot in the motion itself. So I'll have a link to that in the description, so if you want to read the motion in its entirety, it's 23 pages, so I'm not going to read it all on camera. One Peg has a video where he goes through it all pretty in depth on camera, as well as several other documents. So if you want to go look at that, I would say go look at it, just keep some things in mind. So let's move on to their closing thoughts, and I'm going to highlight a couple of points that I think need to be addressed or have some further insight. So he says a couple closing thoughts for the benefit of non-lawyers. One, if IronMace, so he claims to be a lawyer, if IronMace were to win this motion, it would be premised that the idea of everything should be litigated in Korea. As a result, there's no way to tell how this might impact the company's operations without understanding Korean law, which he doesn't have. He doesn't know Korean law. 2, the motion to dismiss are reasonably common. I just pointed that out. 97% of all cases in federal civil cases go to dismissal, usually through settlement. So the fact that they filed this shouldn't account for much. Also true. And lastly, if IronMace wins its motion, then the resulting dismissal likely would be appealed within the Ninth Circuit. Super true. If this is dismissed, Nexon will immediately appeal it. But he says that this means litigation wouldn't be over and likely would continue for at least a year, so unless parties reach a settlement. So again, all of this is mostly true and has been mostly verified by my lawyer buddies. It doesn't really give us much information at all. It's kind of vague. It's all vagary lawyer speak. I don't know if this guy's actually a lawyer or not. I don't know how much you can trust him, but this is pretty par for the course for lawyers. Give vague answers, no specifics, right? Unless you actually need to. So let's dig into the first point. There's no way to tell how this might impact the company's operations. There is, but to better understand it, we must first look into something called the WIPO, or the World Intellectual Property Organization. It governs how intellectual property is handled internationally and what to do in situations exactly like this. Because the WIPO can be somewhat confusing, I have a whole topic devoted to section devoted to this, so I'm going to go over it later. But remember that name for later in the video, the WIPO. I don't want to confuse things, so let's get moving on to point 2. The motion for dismiss are common and shouldn't account for much. So again, thrice barred is mostly correct. However, he doesn't go into specifics. As stated earlier, somewhere around 97% of all federal lawsuits end in a motion to dismiss at some point. However, this is usually through settlement. According to Duke University, also another trusted site, and it's Duke. They're another huge law school. Only 1% of modern federal cases end up going to trial, and 80% to 95% end in settlement. This leaves us with a rate of somewhere between 4% to 19% of all federal cases being dismissed outside of a settlement agreement. The chances for this case could be even less. So the chances for this case to be dismissed through a settlement are extremely high, and it is the most likely outcome, so keep that in mind throughout this entire court case. However, non-settlement dismissal is fairly uncommon. So, there's a less than 20% chance of any case getting dismissed outright. And then you can appeal it. So it's really uncommon for dismissals to happen, and then even more uncommon for them to stick without being appealed. So what I think is the most important point that Thrice Barred makes is in the final few sentences. Even if IronMace does win the motion to dismiss, it will almost certainly be appealed, which is entirely true and entirely possible, as seen in the above mentioned Cornell article. However, what he does not mention is the likelihood that this occurrence forces Nexon into an early settlement that favors IronMace. Both parties want this to be over and to spend as little money as possible. Both also know that they're most likely going to settle at some point, so the fight is really over who gets what, right? It's who gets how much money and what lasting ramifications there are on both companies. So if IronMace wins the dismissal, they could get an extremely favorable settlement fairly early, especially if they also win the Korean injunction battle. And I have win in quotations because they both have injunctions. So if the IronMace injunction in Korea sticks, then and they get this case dismissed, they have a pretty much slam dunk case to settle with IronMace or with the Nexon if they choose to do that. So let's wrap that comment up. Thrice Barred is kind of 3 for 3 as far as I'm concerned. His comments are fairly accurate and topical, if vague. They are super vague. But yeah, go read his whole comment in full. It's worth a quick read. But time to move on to King Rajesh. I don't know how to say his name. Sorry if I butchered it. His comment is fairly small because he claims to be preparing for a trial, so I'll just kind of read it in full. So, forum nonconvenience is always a crapshoot. He's never seen it actually granted in any of his 10 years, assuming practicing law. He says he's a lawyer. but I didn't know about the form selection clauses in the former Nexon employee's contract. That raises the chance that this motion is granted and the case gets dismissed. Doesn't say what chance that is. He says there's a chance. So, take that with a grain of salt. The chance is still small, but there's a chance, right? So he goes on to say, however, IM did affirmatively consent to the exclusive jurisdiction of the Western District of Washington when it contested the DMCA. So by contesting the DMCA, they consented to this legal battle, right? Initially. And he says that I'm not sure how this cuts when it comes to this lawsuit. Usually you have to raise your FNC motion before it becomes moot, and there's an argument to be made that consenting earlier that this motion is now moot, right? That this doesn't make sense because they've already consented. Now he says he imagined Nexon's argument would go, if IM didn't want to litigate in the United States, it shouldn't have consented earlier. So while King is mostly accurate, his comment is pretty vague and based on somewhat based on speculation. There's no real evidence here that his statement about IM having to raise FNC motions before it becomes moot is and it's a little questionable. So this case is somewhat unusual because Nexon didn't respond to the Korean injunction case that IronMace filed until after it had filed the case in the U.S. So they didn't have both. There was no competing and joint lawsuit going on in Korea. It was just Nexon simultaneously filed two injunctions, one in the United States and one in Korea. They filed the one in the United States basically to get the DMCA approved immediately by Steam. So that's why they did it. So they didn't reply to IronMace's injunction until after that had been filed, so there was no joint case. It was just one-sided. And that's important for later. They also waited until IM appeared in the U.S. case to appear in their Korean case, making it nearly impossible for IM to file for the specific type of dismissal until literally right now, because they just appeared like a few weeks ago, and they just went to court as of the 21st. So they couldn't have filed this type of dismissal at any earlier point than they did. Maybe like a day or two earlier, but really they had to have waited till now. So it would have been impossible for them to file this before refuting the DMCA, right? It's logistically impossible. The timeline doesn't match up. So the case in Korea was not ongoing yet. It was just a motion for an injunction. There was no actual Nexon versus IM legal case in Korea. So therefore, forum nonconvenience did not apply. So I don't want to speculate on whether or not King Rajesh is an actual lawyer or not. That's not my place. And I don't know if Bard is a lawyer or not. They both seem to know what they were talking about, at least somewhat. But it does seem like neither of them is really looking into this case too much outside of looking at the documents and then making replies on Reddit, right? So either that or they're looking at summaries and making, partial judgment based on that. Or they're just speaking in vague because that's what lawyers do. So there's a lot more information that needs to be considered when making opinions on this topic. It's kind of like reading a part of an article outside of context and then forming an opinion. It's not usually going to be super accurate or informed. So kind of my opinion is take everything you read on Reddit, in Discord, even from me, take everything you hear, everything you read with a grain of salt. Doesn't matter who it is, unless you know them or you can verify that they are a valid source of information. It's just best to take it with a grain of salt and question everything they say. Now let's move on to something else that stirred up a lot of discussion and some kind of heated arguments in the Discord. OnePeg's video. I don't really like to name names. I really like OnePeg, but I got to break down his video a little bit. And before I break down this hour-and-a-half long video, I want to say again that I really like OnePeg. OnePeg is awesome. I genuinely feel like he's doing his best to make topical opinion-based content that people are interested in. That's kind of his job, and he's doing it really well in my opinion. However, I do think that his brand of content is a little reactionary. He reads these articles or documents live on stream and then forms his opinion right then, right? It's then clipped and edited into a YouTube video, into a better format for YouTube. He's not talking to lawyers, at least not yet. He's talked about, getting IP lawyers involved. But as far as I'm concerned, or as far as I know, he hasn't talked to any experts. He hasn't talked to any lawyers. He's not doing a whole bunch of research and going through multiple sources and looking up like actual legal definitions and legal terms and doing the kind of research needed to formulate a more informed opinion. Not saying that he's not informed. He's pretty well informed. He's way more informed than the average person. So he's not really doing anything malicious or wrong. He's just kind of forming his own opinion live on stream and responding to his viewers, right? And that's really it. There's nothing more, nothing less. So we are, as viewers, the ones who need to keep that in mind while watching that type of content. It's our job as consumers to realize when information is factual or opinion-based. And with that said, let's kind of move on to what he says in the video itself. The breakdown is simple. In this long-ass 1-hour video, one pig reads the entire document and makes several claims, opinions, and speculation about the dismissal. Let's break down what the claims in question are, and then just move on, because I don't want to spend a lot of time on this. So the claims that I have a little bit of a gripe with are that Nexon might be kind of fucked in the U.S. That's purely speculation. This case might not be heard in the United States. Purely speculation. I mean, it might not. It's all obviously opinion. He says multiple times that the judge is going to toss this. That's all speculation. He doesn't know. He's not a fortune teller. Nexon shot themselves in the foot by citing employment contracts in their initial argument. That's an opinion, but it's also kind of a good one. So they did kind of shoot themselves in the foot, because IronMace is throwing their own argument kind of right back in their face. But that might not change much. We don't really know how well that argument's going to play into it, so I'm going to get into that later. If this gets tossed, the DMCA doesn't apply anymore. This is just wrong. This is just hugely wrong. If this gets dismissed, I think Dark and Darker goes back on Steam. This is also, at least from my knowledge, these three things in bold are just straight up bad information. They're just wrong. At least from what I've read and what I've been told from IP lawyers, corporate lawyers, and such. This is just not true. And then in the comments, one pig says, normally I would say copium or hopium, etc. But given the mountain of cited cases here and the overwhelming amount of precedent, I don't see how this doesn't get dismissed. Also, it's likely that Nexon files a rebuttal against this, if only so that they can appeal the decision and bog down the court process even further. So this is mostly opinion. The first half is completely speculation, and his opinion, you could choose to believe it or not. You could choose to listen to him or not. I'm not going to say whether you should or shouldn't, but that's completely his opinion. There's no real factual evidence to prove this. But the second part is very likely, just because that's the most obvious thing that would happen. If the case does get dismissed, Nexon is going to appeal it. I can almost guarantee that, unless it gets settled first. So a lot more was said in this 1.5-hour long video, but these are the points that I felt needed to be addressed. Before I get into anything else, I want to reiterate that one pig's opinion is valid. It's his own opinion, and he's allowed to have it, right? He's allowed to believe and think whatever he wants. That's his choice, and we should all be respectful of it. No one should be boycotting one pig or talking shit about him. I don't want people talking shit about him in my Discord. It sucks to see it in the Dark and Darker Discord. It sucks to see it on Reddit. He seems like a good guy, right? Seems like a good dude who wants to help the fans of Dark and Darker and provide helpful information. And in my opinion, he deserves views and subscribers for it. Anybody who's willing to go out of their way to provide us with content, especially content we don't have to pay for, is doing some good work, right? Even if it's not always factual or true. So I do think that a lot of his takes on this video are somewhat ill-informed and, obviously a little biased towards IronMace, which so are my videos. My videos are, not perfect, and I'm obviously biased towards IronMace. I try to keep that out of it, but it's true. I'm not going to lie. So most of what he says is in this video is basically opinion or speculation, and should be taken as such. To me, it's not really important. That's up to you guys to do with what you want. But what is important is inaccurately assuming how laws work. And there are several points that do this, all relating to how the case gets dismissed, what happens after dismissal, how a DMCA works, and how international laws work. To keep that part short, DMCAs do not require an active case in the U.S. to file. International rights holders can file DMCA requests and cite cases within their home jurisdiction as reasoning for DMCA. If they are a member state of WIPO, the World Trade Organization, or signed the something called the Berne Convention, which Korea is, and has it. That fact is cited in the dismissal itself, right? Korea and the United States are both members of the Berne Convention. They're both members of WIPO, and they're both members of World Trade Organization. So the source, as one peg calls it, is Korea. All parties are based in Korea, therefore Korean IP law takes precedent, as well as Korean injunctions. The U.S. case isn't really necessary in regards to IP law or upholding DMCAs. Should the case be thrown out, Nexon can still enforce DMCAs on IronMace in the United States because they own the United States copyright to P3. And Korea is also a member of WIPO. They already have trade agreements with each other. U.S. Korea are buddies. They both cooperate very closely with each other. My friend is in the military and is over in Korea right now training special forces people and training people how to interact in the DMZ. So they help each other's military. That's how close these guys are. So the two governments are like best friends basically. So these trade agreements in the United States say that they will abide by and enforce each other's IP laws when a company does significant business in the respective countries. So basically, Korean businesses have to promise to abide by U.S. copyright and IP laws whenever they do quoted, this is in quotations because it's important, do significant business in the U.S. and vice versa. U.S. businesses have to do the same while doing business in Korea. This includes DMCAs and the Korean equivalent. So while this does strengthen IM's dismissal case, if it does get dismissed, it strengthens their case, but it wouldn't really change much about releasing Dark and Darker in the United States, at least to the best of my knowledge and from what I've been read and how I've been advised. Now, please remember to question everything you hear and read on the internet unless it's from a verified and trusted source. Neither One Peg or myself are verified sources. We're dudes on the internet. So do your own research and validate other people's opinions. Moving on. What is the likelihood of a dismissal? I don't really like speculating on this stuff, and that's what this is. But, this is my opinion and is completely speculation. But people are going to ask me, so I'm going to give it to you now. In my opinion, it's on the higher end of the spectrum as far as dismissals go. But that spectrum is pretty low. So if you remember from earlier, the average is somewhere between about 4% and 19%. So my guess is there's about a 20% chance that this case gets dismissed. So not too great, but better than nothing. And in my opinion, everything really depends on the employment contract that Nexon had with Mr. Choi and Mr. Park. And we don't have much information on that outside of what we see in the dismissal itself. So what does this mean for the U.S. case? It basically means that there's a small chance that the U.S. case will be thrown out entirely, in which case Nexon will have to appeal the decision and have the case restarted. If that fails, the U.S. case is dead in the water, and if Nexon succeeds in appealing the decision, then IM has a chance to appeal that decision, and whatever the final outcome of that is would be the end of it, right? So needless to say, it could be a huge W for IronMace, or it could simply draw out this process out even longer. That is yet to be seen, and we shouldn't really get our hopes up. With that said, what does this mean for the Korean case? Does it have any bearing on the Korean case? Well, the point of that is that the U.S. cases getting thrown out would benefit IronMace in a lot of ways. Most of it is financially. If the U.S. case is dismissed, IronMace would have a lot more money and time to dedicate to the case in Korea, which is arguably more important. It would also be a good signal of strength from IronMace's legal team, which is always a good thing. Getting a W anywhere you can is always a good thing in a legal battle. Other than that, it wouldn't really change much. But let's understand why I said some of the stuff I said. And to do that, we have to know what the WIPO and the World Trade Organization is, and what that Berne Convention is. So this is kind of the meat of it. Why am I saying the things I'm saying? Well, the WIPO is super important. So is the World Trade Organization and the Berne Convention and the UN for that matter. And the WIPO stands for the World Intellectual Property Organization. They're an international body of member countries that agree to uphold and validate each other's intellectual property and copyright laws. They also set international standards for IP and copyright laws, as well as act as an intermediary for international IP and copyright disputes. Exactly like what's happening right now in Korea with Nexon and IronMace, and in the US, at least for the time being. A lot of their job is to inform international courts and mediate cases exactly like what we have with Nexon and IronMace. According to their website, the World Intellectual Property Organization is a global forum for intellectual property, services, policy, information, and cooperation. We are a self-funding agency of the United Nations with 193 member states, so almost every country in the world. Our mission is to lead the development of a balanced and effective international IP law system that enables innovation and creativity for the benefit of all. Our mandate is governing bodies and procedures are set out in the WIPO Convention, which established WIPO in 1967. So a lot of these decisions and the principles that the WIPO operates on were formed during something called the Berne Convention. Now, the Berne Convention was adopted in 1886 and deals with the protection of works and the rights of their authors. It provides creators such as authors, musicians, poets, painters, etc., with the means to control how their works are used, by whom, and on what terms. In short, and that's for a global standard, right? They kind of established a goal. All these countries came together and established a global standard for IP. In short, the WIPO is the intellectual property and copyright branch of the United Nations, and they work very closely with the Hague and the World Trade Organization for enforcement of IP and copyright issues. Now, it's kind of what all international copyright law flows through for all member countries, along with the WTO, World Trade Organization. They kind of handle enforcing copyright and IP around the globe. Now, what do they have to do with the DMCAs, and what does this have to do with DMCAs? To be short, honestly, not much would change. The U.S. and Korea are both UN, WIPO, and World Trade Organization members, meaning companies from each country have to follow the other country's IP and copyright law if they do significant business there, which both Nexon and IronMace does. 40-something%, I think, of the player base of Dark and Darker comes from the United States. So IronMace has to follow U.S. IP law if they want to continue doing business in the United States. Essentially, while doing significant business in the U.S., IronMace and Nexon are both held to U.S. IP laws and copyright laws, and Korea agrees by it being a member of these things to enforce them, even though they are based in Korea. It would quite literally require government intervention to not uphold U.S. laws in this case. So this also includes DMCAs. I'm not going to start reading from a bunch of articles, but I'm going to have these linked in the description. I'm getting this directly from the American Bar Association. I'm getting this straight from copyright.gov and the Federal Register of the United States. You can find a link right here, federalregister.gov, copyright.gov/international issues. I'll have these linked in the description. So no, a dismissal does not mean an end to DMCAs. That's completely wrong. They just need to have a case going somewhere, specifically in their home country, that is also in agreement with the WIPO and the Berne Convention. They need to have a case going there, and they needed the US-based lawsuit to get the DMC going immediately, right? Because they wouldn't have had time to file the DMCA and then go through the WIPO and do all that stuff before basically IronMace would have had EA out by the time they did all of this stuff, right? They wouldn't have been able to file the DMCA until fairly recently, in which case early access would have already been up. So that's why the U.S. case was so important, because it would have cut the time needed to do this from like 2 months to get the DMCA to a week, right, or 2 weeks. So it was just a lot more expedited. It was a lot more expedient, and it cost IM a lot more money to start the U.S. case up, because now they have 2 court cases. It well more than doubled their legal fees. So having an active U.S. case does make it a lot easier to file a DMCA, but it doesn't make it. But not having one doesn't make it impossible. It's just going to take longer, right? So unless an injunction is placed against Nexon in U.S. or Korea, they could still go through the WIPO and World Trade Organization to seek a DMCA. This process will take a lot longer and be less convenient for Nexon, and probably more expensive, but it's still entirely possible. So what does this mean for early access? I mean, that's all anybody really cares about, right? So what does this mean for early access, and what's the TLDR for this whole thing? Well, I kind of wish I had better news, but this means that early access is mostly dependent on the Korean lawsuit, no matter what. If Nexon is slapped with an injunction in Korea, IronMace can proceed as normal while everything goes through the appeals process. If IronMace is slapped with an injunction, they can't release Dark and Darker regardless of the U.S. court case. So either way, if IronMace loses the Korean injunction battle, they can't release Dark and Darker. But there's always the possibility of a mutually equitable modified injunction that kind of gets put on both of them, where, and this is the most likely scenario in my opinion, where IronMace has to set aside a bond in order to release Dark and Darker. So like a percentage of sales would have to be set aside in a separate account that's controlled by the government. And then Nexon can't send any more DMCAs globally. So, and IronMace still gets to release early access. That's, in my opinion, the most likely outcome, whether it's the United States or Korea. But yeah, a dismissal in the United States doesn't really change too much and is somewhat unlikely to begin with. However, it does have a better chance than most dismissals, at least in my opinion. What it would do really is strengthen IronMace's legal case in Korea a little bit. It would save them a lot of money in the long run, and it would save them a lot of time that they can then spend developing the game or preparing for Korean court. If nothing else, it puts a lot more pressure on Nexon's legal team and costs them more money to fight, because now they are the ones who have to fight with an appeal, right? So all around, this was a really smart play by IronMace and their legal counsel, and we should all be super happy that they're fighting this hard. But that's really all I know for now, but we're going to see how this kind of plays out. So yeah, in closing, I hope you guys liked the video. I hope this video helps clear some things up. You know, I really don't want to ruffle any feathers with, you know, King or Thrice Barred King or One Peg. I really appreciate their insight and their videos and comments and remarks. They're all awesome people, and I hope they keep doing what they're doing. But yeah, if you guys like what I'm doing, please consider subscribing to my channel, joining my Discord, and becoming a patron. I do post all of my scripts early on my Patreon. I also post the videos when I can early, and I do post some like insider information about my game and my helpful game studio and all that kind of stuff. And access to get to all that stuff is just $1 a month. So be sure to check it out. Just follow all the links in the description below. Again, thank you guys so much for watching. Everything you guys do, from clicking the thumbs up to, you know, just initially clicking on that thumbnail and leaving a comment and subscribing, it all helps keep the channel going. It also helps me realize my dream of opening up my own game studio and developing my own games. So yeah, you guys are amazing. As always, if you have any questions or concerns, or just want to yell at me, feel free to let me know in the comments. I hope you guys have an awesome rest of your day. I'll see you guys in the dungeon. Peace.